Thank you all for coming. My name's Paul Alger and I'm Director of International Business for the UK Fashion and Textile Association. No, we haven't moved, although we have gone up in the world, thanks to the support from our very dear friends at Fox Williams who have agreed to host us this evening. So thank you very much for that. And it's a real pleasure to see you not behind a screen, but in person. Again, Fox Williams were very insistent. They didn't want to do a webinar. They wanted a face-to-face event. And I absolutely agree. It is lovely to be in the same place as people, to meet up, to exchange ideas, to decide whether you're going to hug, shake hands, kiss, or just sort of do the British thing, which is say hello. So I'm delighted that you're all here, and a very interesting mixture of people you are indeed. So there are agents and brands. That's always quite an interesting challenge for this type of topic that we're going to talk about this afternoon or this evening. We have textiles and fashion, we have children's wear, women's wear, and others. So a very nice cross section. So before I hand over to our friends at Fox Williams, just a few words from me. I'd like to be able to say that it's wonderful to sort of see you in the same way that we always did before, but as we know, everything has changed. Not only has COVID come to disrupt our lives, but so too has Brexit. So nothing is quite the same again. I won't go too much into the detail on Brexit, but a lot of the context for UKFT wanting to work with Fox Williams on today's event is helping companies to understand what has changed post Brexit, and what companies need to be thinking about. Agency legislation may or may not have changed. You'll be hearing about that in a moment, but the business environment that you are all working with certainly has, both in the UK and internationally. So there are going to be a few questions that I hope we'll pick up as we go through, that will be important, and some of them will be looking at the UK situation. Others will also look at the export side of things, which is obviously, for those of you who know me, is my keen area. And then if there is time at the end, we're going to take some questions. So I'm going to suggest, if I may, that we take questions at the end, because otherwise Steve and his team will probably be covering everything. They go into a lot of detail. They're very well prepared. And then we will take questions afterwards on anything that you'd like to talk about. And then after that, if I'm not mistaken, we're being treated to drinks and some nibbles, food of some description. I haven't seen what it is at the back. So I hope you will stay and join us for that. So in the meantime, if I can hand over to Steve and his team to take us through the nuts and bolts of this evening. Thank you very much.
Thank you very much indeed, Paul, and good evening, everybody. My name is Steve Sidkin. I'm partner at Fox Williams. I lead the agent law team at Fox Williams, which is a group of litigators and commercial lawyers who are involved on a day-to-day basis with agency agreements, distributorship agreements, supply agreements, and inevitably terms and conditions of sale, terms and conditions of purchase. I also chair our fashion law group, and it's a group of lawyers from different parts of the firm. So we have employment lawyers, we have property lawyers, we have IP lawyers, we have commercial lawyers, we have corporate lawyers and litigators who again are regularly involved in acting for companies in the fashion industry, whether they're brands, whether they are suppliers, wholesalers, retailers, everyone in the fashion industry. And in fact, those who provide services to the fashion industry. And by way of example, one of the matters that I think Millie and I worked on relatively recently was in respect of an influencer agreement for one of our fashion clients. So we get to see what life is about so far as the fashion industry is concerned. And it is, at the moment, unfortunately, a hard life. Yesterday, to the amazement of my team, I took a day's annual leave and I found myself in Knightsbridge, in Harvey Nichols, and I was surprised to see signs up proclaiming seasonal discounts. And I had to remind myself where we are in the calendar. I was not expecting to see seasonal discounts towards the end of April in Harvey Nichols, but there they were on show. So it is a hard time, unfortunately, but hopefully with legal advice, things can be a bit better. I hope so. So we're going to talk about a number of topics this evening. First of all, I'm going to talk about the importance of terms and conditions of sale and purchase. I'm then going to hand over to Hannah, and Hannah's going to talk about force majeure and frustration. Force majeure, I anticipate that many of you will have heard of, but perhaps not be entirely certain as to what it's about. Frustration, yes, I know we can all get frustrated. Let's start with the government and work our way forwards from that. Hannah's going to be referencing frustration in the legal sense, not in the perhaps in the actual sense. And then Hannah's going to hand over to Millie to talk about the consequences when contracts are not fulfilled for the seller, for the purchaser, for the agent, for the distributor. They all have certain consequences, and we're going to look at a number of those when we come to Millie's talk. And then, as Paul has mentioned, if you do have questions, please do keep them until the end, and then we will try and answer them, and then we will adjourn for drinks, for canapes, for talking about various issues, and hopefully addressing anything that you would like to address on a one-to-one basis as opposed to in an open meeting. Okay, so let's talk about the importance of terms and conditions of sale and purchase. Some of you in the room will play chess. Some of you will participate in playing tennis from time to time. You'll know, for those who engage in either activity, that if you start first, if you hold the white pieces, if you're the first to serve, then you do have an advantage. And to be in a position where it's your terms and conditions of sale or it is your terms and conditions of purchase which represent the terms and conditions of the contract between you and your purchaser, you and your seller, in other words, the party that is selling to you, that can put you in a very, very considerable advantage so far as the contract is concerned. And why is that? Essentially, it's because terms and conditions of sale, terms and conditions of purchase represent a legal framework for the contract that is being made between the parties. That is not to say necessarily that they represent the entirety of the contract. Lawyers are generally liked, and I use the word liked in inverted commas, by the rest of society because for a number of reasons. Sometimes it's because of their ability to always find lawyers with two arms, because they're able to say on the one hand this and on the other hand that, but also because when it comes to it, they can be inventive so far as their clients' needs are concerned. And we can get to situations such as the concept of force majeure, such as the concept of frustration, where lawyers, depending on who they're acting for, possess ability to see things from their client's perspective and perhaps come up with answers that might not otherwise appear from what is before them so far as documentation is concerned. So it's a legal framework, and it is protective of the seller or the buyer, as the case may be, or perhaps should be protective. And I say should be protective because, one, the terms and conditions need to be properly drawn up. All too often, Hannah, Millie, others in the team, we see situations where it is quite clear to us that the client that has come to us and who is showing us the terms and conditions, whether it is their terms and conditions or the terms and conditions they have been sent, those terms and conditions have been, quote, borrowed, end quote, from another source. This is particularly the case where you go online and you go to a particular brand's website and you look at the particular things that they have on the website, whether it's their terms, conditions, or for that matter, their privacy policy or terms of use, and you think, oh yeah, that looks familiar. Well, it looks familiar to lawyers. Why is it familiar? Because all too often what has happened is that they have gone to somebody else's website and copied and pasted what they've seen on somebody else's website, so far as their own website is concerned, and they say, these are our terms, conditions, these are our privacy policy, or this is our privacy policy, and these are our terms of use, without actually thinking that one, what they're doing is copying somebody else's work. Two, whether they're simply reproducing somebody else's mistakes. Three, whether what they're doing actually works so far as their own business is concerned. And added to which, just for the record, what they're doing is infringing copyright, and that is theft, so far as our law is concerned. But we do see it. But more particularly when it comes to terms, conditions of sale, terms, conditions of purchase, what we see all too often is that whilst the terms, conditions hopefully have been, the backing's still there, hopefully have been properly prepared, they've not been properly incorporated into the contract which has been made with the seller, with the purchaser, as the case may be. And that leads on to something which is called the battle of the forms. And some of you may have heard of that phrase before. And I'll describe a situation in respect to Brantano. Some of you may remember that Brantano was, for a number of years, a footwear retailer in the UK. In or around about 2016, 2017, it went into administration. It was rather unfortunate. Equally, it was rather unfortunate that one of our clients was a supplier to Brantano. And so Brantano goes into administration. The administrators are appointed. They come to our client and they suggest to our client, quite understandably, that the terms and conditions of sale, which our client thought were in place between it and Brantano, are not in place. Why? Because on each occasion that Brantano placed orders with our client, and our client said, thank you very much for your order, we're pleased to accept your order, or not, as the case may be, because sometimes the quantities ordered of particular styles, particular sizes weren't acceptable to the client, but we're prepared to accept this or that, and these are our terms and conditions of sale. And Brantano would send a communication back, because Brantano was acute, but not in a Disney-like sense. And Brantano would send a communication back which would say, thank you very much for your confirmation of our order. We are pleased to accept your confirmation, and our acceptance of your confirmation, our client's confirmation, is on the basis of our terms, conditions of purchase, see www. And then go from there. Or see the back of our confirmation of your acceptance. And it would go backwards, forwards, forwards, backwards, until unfortunately our client gave up. And we left that, or we find ourselves, or we did find ourselves in a situation where our client, so far as Brantano is concerned, was supplying goods to Brantano where it thought it had its own terms, conditions of sale in place. It did not. That was the advice that we gave. Instead, Brantano's terms, conditions of purchase were in place, and unsurprisingly, they were favorable to Brantano. Unsurprisingly, they did not provide for our client to have retention of title so far as the goods supplied to Brantano was concerned. Haha. So we're called in, we advise. Ultimately, we do a deal with the administrators, which means that we get paid something for the stock that the administrators are effectively holding on behalf of Brantano. And we explain to the client that going forward, this is what it needs to do in order to avoid a similar situation occurring in the future with other customers. 12 months go past, or approximately 12 months go past, we're contacted again by the same client. Brantano, having been bought out of administration, has now gone into administration the second time. So we said to the client, can we just check that when we gave you the advice about putting in place your terms and conditions of sale, that you actually follow through on that? At which point there was a very studied look of the colour of the carpet tiles, as they decided that it would be better to look at the carpet tiles than to look us in the face, figuratively speaking. Because essentially what had happened is that Brantano had played the same trick again. And each time our client had sought to put in place its terms and conditions of sale, Brantano had batted back and batted back successfully. And again, we go through the same scenario with the administrators. Two very expensive exercises so far as our client is concerned. I would like to say that that was a one-off. I'd be fibbing to you if I was to say that it was one-off. We have seen it too many times, and it shouldn't be like that. But if it were a perfect world, we wouldn't have half the work that we have in the office, and that's true, I think, of most law firms. So what really works and the consequences? What really works? Sometimes what we see, in fact, we do see it quite frequently, is references are made to terms conditions of sale when the invoice goes in to the customer. We've got a situation such as that at the moment. I'll come on to it in a minute or two. But when you think it through, logically, it just does not make sense. Why? Because invariably, it is the invoice which is one of the final acts of the contract in terms of the performance of the contract, which means that the contract has to be in existence before the invoice goes in, before there is a reference to the terms and conditions of sale. So simply putting reference to, thank you very much, here's our invoice, and the invoice says in small print towards the bottom, for our terms and conditions of sale, please see www. And then the name of the company, .com.co.uk, whatever you want. It doesn't work like that. For sure, it is no bad thing to reference your terms and conditions of sale on an invoice, but not to have incorporated them into the contract at the time the contract is made is fatal. At best, if there have been a series of contracts made between seller and buyer and the same parties, at best, there might be an argument to say that by reference to what is called course of conduct between them, that the terms and conditions of sale have been incorporated, but it is a weak argument to begin with, and an argument which I would suggest sellers should not be having with their customers, because if that's the best you've got, it isn't very good. And so what can happen in that situation where your terms and conditions of sale have not been incorporated in the contract and the purchaser doesn't have terms and conditions of purchase? Well, in that situation, we fall back on the statute law on the Sale of Goods Act and other legislation, such as, for example, the Unfair Contract Terms Act. The Sale of Goods Act is not bad. It's intended to represent a middle point between seller and buyer, but for sure, it is not as good by any stretch of the imagination as having your own terms and conditions of sale, or if you're the purchaser, your own terms and conditions of purchase in place. It just isn't as good. And also, by reference to the Sale of Goods Act, we would also be looking in that situation to relevant case law. And case law may be helpful. It may be very helpful to the party that you're against, whether that party is the purchaser or the seller. So where can it all end up? And I've got here the case of the German distributor. Yeah, it can all end up in a situation that two of our clients are actually facing at the present time. One of them is a distributor and agent for a German supplier. The other is a UK company which has been supplying a company in Germany, and that company has been acting as a distributor and agent. And where it can all end up is in a very painful position for certainly our client that has this German distributor or agent, because it didn't use its own terms and conditions of sale. It didn't have any. It didn't incorporate them into contracts that it entered into. In fact, the contractual relationship with this German company is now at an end. And again, we have been called in to try and dig them out of that particular hole. Because not only are they in a situation where the German company owes them money for goods supplied, and the amount involved is nudging six figures, but at the same time, the erstwhile German agent come distributor has the potential for various claims under German law for the ending of the agency and the distributorship agreements between the parties. So at the moment, so far as that particular matter is concerned, it's the equivalent for us of playing hopscotch in a minefield, not to be recommended. Conversely, where we're acting for the UK company against the German supplier, we find ourselves in the same situation, but on the other side. And so what we have asserted against the German supplier is that, yes, we do owe you. And I think in that case, it's around about 170,000, 190,000 euros. We admit we owe you that, but we're going to set that off against the amounts that we are owed, or we claim we are owed, in terms of the wrongful termination of our agency agreement, the wrongful termination of our distributorship agreement. Oh, hey presto, we now only owe you 70,000 euros. And we've managed actually to get them down to, I think, to 50,000 euros, and that payment will be made. So in that situation, the client has managed to effectively secure 190,000 euros worth of product for 50,000 euros. Not a bad business to be in. One of the things that is important, and it's important not only when we talk about the terms and conditions of sale, the terms and conditions of purchase, the contracts made with your agents, your distributors, the contracts that your agents and distributors make with their suppliers. One thing is very, very important, and that is clear wording. I'm going to move on now to hand over to Hannah to talk to you about force majeure and frustration, and you'll see the importance of clear wording, particularly in the context of force majeure. But before I do so, some of you may have seen on the BBC News website this from, when was it now, 21 April. It's talking about Transpennine Express, worst for train cancellations. I think it was in late January of this year, the BBC were again carrying a news story about Transpennine and about the poor service that it was delivering for its customers. And they had someone being interviewed on behalf of Transpennine who promised that Transpennine would improve the services for its customers, for its passengers, by pulling out all the stops. Now, clearly, if you pull out all the stops, the trains are going to run on time. Let me hand over to Hannah.
Thanks, Steve. So, as Steve said, next I'm going to talk about what happens when something goes wrong under a contract, particularly when the thing that goes wrong is actually out of the control of the parties to the contract. So I've included on this slide a picture of a ship called the Ever Given. And you may well have heard of the Ever Given in the news. So back in 2021, there was a blockage of the Suez Canal, and it was caused by the ship, the Ever Given. And now the Ever Given is one of the largest container ships in the world, and it had been making its journey from Malaysia to Amsterdam when it bashed against the side of the Suez Canal and held up all of the ships behind it. Now, it actually blocked the canal for 5 whole days, which had a massive impact on supply chains worldwide, particularly because the ships behind the Ever Given had to either take an alternative route or they just had to wait for the blockage to clear. Now, there's one company that definitely remembers the Ever Given, and this is Kingsway Golf Centre in Cambridge. And they host the crazy golf course Jurassic Links. And they had been waiting and expecting Dino the dinosaur shown on this screen, which is a 10-metre dinosaur that had been carried within the Ever Given and arrived 5 months late. The hold-up in the Suez Canal also had a massive impact on the fashion industry. And in particular, we act for a footwear brand that found itself into great difficulty when hundreds of pairs of shoes were held up on the ship, or as a result of the blockage caused by the Ever Given ship. So what rights do businesses have when their supply chains are interrupted by unexpected events? Well, many people are familiar with the term force majeure, but what does it actually mean? And how do force majeure clauses actually help parties deal with their contractual uncertainty? Well, the first point to note is that there is no English law principle of force majeure, and therefore, in order to rely on force majeure, your contract must actually contain a force majeure clause. And usually, what a force majeure clause will do is that it will excuse either one or both of their parties from performing some or all of their contractual obligations when certain specified events occur. And the effect of a force majeure clause, if triggered, will usually be that one party will not be liable to the other for their failure to perform the agreement. So in a way, it really helps in those scenarios where something unexpected happens and the parties just can't perform the contract. But even if an agreement does contain a force majeure clause, you might not necessarily be able to rely on it. And the reason for this is that because the wording of the force majeure clause is really, really important. And the level of help that you'll get from that clause depends on the way that the clause is drafted. So if, for example, a clause had said that the parties will be discharged from their obligations where there is a force majeure event, this is unlikely to be effective. And the reason for that is that the term force majeure is actually a French law concept, and it has no real meaning in English law. So a clause should set out the specific events that will trigger the force majeure clause and activate the clause. Now, obviously, this involves a bit of crystal ball gazing at the outset of the negotiation of the contract, but it can be really critical when things go wrong. And this is something that we've definitely seen in recent times in respect of COVID and Brexit. So where Brexit is concerned, the courts were faced with a number of questions as to whether Brexit had triggered the force majeure clause. And unsurprisingly, the answer ultimately came down to whether the force majeure clause actually referenced Brexit in the first place. Similar situations were faced as a result of the COVID pandemic, particularly when the restrictions first came into place. And as lockdowns were announced, we were very busy checking clauses for our clients in order to try and dig them out of holes and find some way to justify non-performance of a contract. And again, ultimately, the answer comes down to the wording that's used in the contract. So before COVID, it was very common in a force majeure clause to see reference to an epidemic, not so common to see reference to a pandemic. And the World Health Organization actually defined COVID as a pandemic. So in the future, we definitely expect to see and definitely be putting in our clients' force majeure clauses reference to both a pandemic and an epidemic. But we might not even stop there, because if you think back to the COVID pandemic, the reason that companies couldn't perform their contracts was often down to government regulation and advice. So in addition to making reference to a pandemic and an epidemic, we would also expect to see reference to government regulations or laws that affect performance of the contract in general. And finally, it's worth considering what happens when a force majeure clause is triggered. So you find that the certain event that's listed in the agreement has actually occurred. And what happens there, unsurprisingly, depends on what the clause says. So sometimes you'll see reference to termination of a contract when the force majeure clause is triggered. But then some other times you might see reference to suspension for a defined period, which is perhaps for as long as the event is continuing. And another thing to check out for is formalities, because a contract will also often contain formalities that must be followed in order for the parties to benefit from the use of this clause. So if you have to notify the other party that there's a pandemic, make sure you do that. Otherwise, you just won't get the benefit and the value of the clause in the first place. Okay, so moving on to frustration, another potential remedy in the event that something goes wrong under a contract. And I think, as Steve mentioned, it's fair to say that this is a lesser well-known concept. And the reason for this is probably because it's an English common law concept. And so there's no requirement for the parties to mention frustration in a contract in order to be able to benefit from it. Also, unlike force majeure, the effect of frustration does not depend on what's written in the contract. The effect is simply that the parties will be completely discharged from their obligations at the time that the contract is said to have been frustrated. So how does a party prove that their contract has been frustrated? Well, there's quite a strict test, and ultimately, this is that the contract has been either physically, legally, or commercially impossible to fulfill. So the result is that the contract that the parties would perform, given the frustrating event, would be fundamentally different to the contract that the parties had envisaged at the negotiation stage. On the slide, I've included a picture of King Edward VI at his coronation in August 1902. And it was around this time that the modern law concept of frustration was developed. And the reason for that was that because King Edward fell ill with appendicitis just 2 days before his coronation, and this resulted in the event being delayed for 5 months. And in one particular case, the court agreed with a claimant that their contract for the hotel room that they'd rented to watch the coronation from had been frustrated because that individual had entered into the contract for the sole purpose of watching the coronation from that room. So when the coronation was cancelled, the claimant could not benefit from the fundamental purpose of the contract. You know, they fundamentally entered into that contract for a very specific reason. And in the absence of that, the contract had been frustrated. There's another old case that relates to a contract for the hire of a music hall. And this music hall had been hired for a series of concerts. But before the first concert was able to take place, the music hall burnt to the ground. Again, the court agreed that the fundamental purpose of the contract had been frustrated, and therefore the parties were discharged from their obligations under that agreement. And since these early cases, the Law Reform Frustrated Contracts Act 1945 was introduced into English law in order to provide a framework for dealing with frustration cases. However, we were discussing amongst ourselves the other day, and we think it's probably fair to say that this is not really well known by lawyers because frustration rarely ever comes up in practice. And the reason for that is because of the very high bar that you have to overcome in order to prove that a contract has been frustrated. And various attempts have been made over the years to argue that contracts have been frustrated, but on nearly every occasion, the English courts have refused to find in the claiming party's favour. And the reason behind this is that the courts will generally prioritise prioritise giving effect to the wording in a contract and the intentions of the parties above everything else. So if the parties haven't thought about supervening events that may occur and given effect to those in a contract, it can be really difficult to prove that the contract has been frustrated, and the parties can part ways and the contract will be the contract will come to an end. However, we have seen a recent case that's come through the courts, and it was against British Airways, and this case in particular relates to frustration. The case was brought by an individual, and she had booked a trip to Japan with British Airways. And this was just after the COVID restrictions in the United Kingdom had eased. But the trip was cancelled, and the reason for this was that the restrictions in Japan were still very strict. And therefore, the claimant was issued with a voucher from BA to compensate her for the missed flight. However, the problem was that this voucher expired before the restrictions in Japan had been eased. The claimant claimed that this had rendered her contract completely ineffective. She couldn't use the voucher for the purpose for which she wanted to use it initially. And after being denied a refund, she went to the court and asked for damages and asked for them to confirm that the contract had been frustrated. And to our surprise, the court agreed with her. Now, this might be quite a shocking position to take, and particularly worrying for businesses, because as far as British Airways were concerned, they had provided a very common solution to what was a very common problem at the time. But in successfully making a claim for frustration, the claimant cast the appropriateness of that solution into doubt. And it also potentially raises further questions of whether service providers will be required to refund rather than offer vouchers in the event that future events are cancelled. So one thing's for sure is that this has definitely kind of changed the tide in terms of frustration claims, and it'll be really interesting to see whether future courts decide to follow suit and, I guess, develop the principle of frustration going forward. And finally, I just thought it might be helpful to recap on frustration and force majeure. And I think the main point to say is that, firstly, both principles deal with uncertainty in contracts. The force majeure can be relied on if a contract provides for it, but only if a contract provides for it. Whereas frustration is a common law principle, and that will be available to the parties regardless of what a contract says. Certainty is obviously a big positive for force majeure. So if you suffer an event that's neatly called out in the force majeure clause, then that's probably a good result for you. Whereas frustration is a lot more difficult to prove, and it's a lot more uncertain. So you can't be sure that you can rely on frustration in order to get out of your contractual obligations. So thank you. And I'm now going to hand over to Millie.
Thank you very much, Hannah. As Hannah said, my name is Millie. I am an associate in the Commerce and Technology team here at Fox Williams. And today I'm going to be speaking to you on the topic of the impact which non-performance of a contract can have on each of a seller, a buyer, an agent, and a distributor. First of all, what is non-performance? Well, it's exactly what it says on the tin. Non-performance is when one party to an agreement, for one reason or another, fails to perform their obligations underneath the agreement. In a contract for the sale of goods, such as clothing or footwear, it is the duty of the seller to deliver the goods, and it's the duty of the buyer to accept and pay for the goods, in accordance with the terms and contract of the sale. If one party doesn't perform their end of the contract, then this can have enormous implications for the other party, particularly in a supply contract where the supply chain may be extensive and the parties may be reliant on this. So this is scenario one. Scenario one shows a standard supply contract between a seller and a buyer. although I have used a fake scenario in scenario 1, I have used real fashion brands to help demonstrate the point. So in this case, the seller is the less fortunate Arcadia, and the buyer here is Selfridges. By way of quick background on myself, before embarking on my career in law, I worked in the merchandising team for Arcadia, so gaining valuable experience in supply chain management, hence the use of this example. In this scenario, the seller, Arcadia, is selling their clothing products themselves directly to Selfridges, who buy them outright and then sell them on to the end customer, us. The starting point when assessing issues of non-performance in any scenario should be, firstly, 1, what does the contract provide in the event that there is non-performance? Secondly, if there is non-performance, is the other party able to claim for damages? If yes, what are the extent of the damages that it's able to claim? And finally, could a seller who has been affected by a buyer's breach claim for damages in terms of the profit that it would have lost as a result of the contract not being performed? When we're looking for the answer to these questions, it can usually be found in the terms and conditions of sale, as Steve was talking about earlier, which should have been incorporated into the contract between the buyer and the seller. I say should rather than a definitive answer, based on the unpredictability of supply contracts and some of the reasons that Steve touched upon earlier. Under the Sale of Goods Act, which governs B2B or business-to-business contracts, in the case of a seller not delivering the goods that they have promised, the buyer may have an action in damages. Damages are to be calculated by looking at the estimated loss directly and naturally resulting from the seller's breach in the ordinary course of events. The courts may also look to the current market value of the goods when measuring appropriate damages. Where the buyer is at fault for the breach, the seller may have an action for the price of the goods, as well as damages for wrongful non-acceptance, calculated in that very same way. In some situations, a court also has the power to order specific performance of the contract, ensuring that the contract is performed regardless of the breach. However, this is rare when damages are appropriate. So what about if the contract is silent on non-performance? Well, in this case, unless there is a specific statement or clause in the contract regarding remedies, the usual remedies that are in place for breach of contract are available to the party that is wronged by the breach. A wronged party may also be able to rely on the common law remedy of repudiatory breach. This is a breach of contract that gives the innocent party the right to treat the contract as being disregarded and entitling the innocent party to refuse to be bound by its terms. To be available as a remedy, the breach must go to the core of the contract and must substantially deprive the innocent party of the absolute benefit that the contract was intended to provide. A repudiatory breach allows a party to choose whether they accept the breach, bring the contract to the end and seek damages, or waive their right to terminate and instead affirm the contract and seek damages, or waive the breach altogether and accept the defaulting party's performance. In the case of long-term supply agreements, although those last two options don't sound particularly enticing, these are options that may be considered. I'm now going to move on to scenario 2, or 3. Scenario 2. So here we have an agent. So I'm sure many of you are familiar with the concept of agents, particularly commercial agents. So in this scenario, we have Arcadia is still the seller, but they are the principal. Arcadia here is looking to branch out to get their products into luxury department stores. They don't have this knowledge, and therefore they work with an independent commercial agent who is well versed in luxury department stores, who acts on their behalf and with their authority to liaise and sell the products to the buyer, Selfridges. Brands often choose to use agents when an agent has this greater scope of market knowledge and can help them infiltrate new market areas and customer bases. Usually, where an agent is involved, they will be acting for the seller as a selling agent. However, buying or purchasing agents do also exist and are also covered by the commercial agents regulations, particularly in the garment industries. But where the agent is acting for the seller, the most common scenario here, and the contract is not performed, then if the reason why the contract has not been performed is a reason which is attributable to the seller themselves, for example, failure to supply the buyer, then the seller could find itself the subject of a claim by the agent for back commission on the contract which has not been fulfilled, in addition to any claim the buyer may have against them, as in scenario 1. If there is a situation where Arcadia, as a seller, makes a commercial decision not to have the totality of orders made up, and subsequently decides which stockists get the stock, they also put themselves at risk of a claim in back commission from their agent. So even though the seller doesn't perform the contract, doesn't collect any proceeds of sale or any likely profit, it may still find itself even more out of pocket by being subject to a claim from commission from the agent on the unfulfilled contract. Depending on the extent of the non-performance, or in a situation where a series of contracts are in place that the agent has had a role in instigating, the agent may get to a position where they're able to say that the seller principal's non-performance of the agency agreement is so severe that it has broken the agency agreement and terminated it. Those of you in the room that are agents know what's coming next. The agent can then choose to accept the non-performance as being severe enough to bring the agreement to an end and claim for compensation or indemnity under English law. This, of course, turns a bad day into an even worse day for a seller principal. By way of a quick reminder, and for those of you who are new to agency, in an agency situation, upon termination by a principal, an agent that is a commercial agent under the commercial agents regulations is entitled to seek either compensation or indemnity from the principal. Compensation is applied by statute, and without any other agreement saying otherwise, it is the default which will apply to all commercial agents operating their agency in Great Britain. Typically, compensation is the preferred remedy for agents, particularly high-performing agents, as it is an uncapped remedy. If you would like to find out more about how the calculation of compensation payments happens, if you scan the QR code in your pack from this slide, it will take you to the recording of our Fox Williams Agent Law Seminar, which happened in January 2023, discussing this subject, where we speak to Stuart Burns from H.W. Fisher. Indemnity provisions, however, may be expressly elected for by the parties and will not apply unless there is that express election. Indemnity provisions cap the potential payment to agents at a maximum of the 1-year average of the last 5 years of commission. It provides much more certainty to principals, particularly in a situation where non-performance is involved, to the point where an agent may be entitled to say that the seller principal has brought the agreement to an end. The principal knows what they are on the line for. Even if the agent doesn't make a claim for back commission, as I discussed earlier, or is not in a position to be able to say that the seller's performance could bring the agency agreement to an end, the agent may still be able to claim relief in the form of damages. This is because there is a legal obligation on the seller as a principal to act dutifully and in good faith in accordance with the commercial agents regulations. It's possible, in the case of non-performance, to put forward a decent argument to say that if a seller is not performing their duties under a contract, then they're not acting dutifully towards their agent. And therefore, that is the point where a claim for damages can then arise. In this case, the agency agreement would still continue as normal. It would just be that the agent has a claim for damages if they wish to pursue it. And finally, scenario 3. So scenario 3 relates to distributors. So distributors, first of all, are not protected by their own set of regulations like agents are. However, damages claims are still very much open to them. Here we have the seller Arcadia, who sells their products outright to a third party, creatively named, I don't know who came up with this, MP Distribution. So MP Distribution buy the products from Arcadia. They then resell those products themselves to the end user, Selfridges, who then sell on to the customers. In this case, it's kind of 2 separate contracts. So you've got the contract between the seller and the distributor, where the distributor is the seller's buyer, and then the distributor becomes the seller with Selfridges. As distributors are independent parties and are not an extension of the seller principal like agents are, we once again look to the terms and conditions of sale. If there is non-performance, and arguably non-performance to such a degree as to show that the seller is not performing the overall distributorship contract between the seller and the distributor, is the distributor able to claim for compensation? Well, technically, no. Yet, over the past 14 years or so, the courts have shown themselves to be increasingly willing to recognise that there can be a claim for compensation for distributors, which is in many ways comparable to the claim that an agent will have for compensation on the loss of their agency agreement. A distributor that is claiming for non-performance may find that a court, in calculating an appropriate damages payment owed to them, looks to calculate damages in a way comparable to the way compensation is calculated. So in other words, the value of the distributorship to a notional third-party purchaser. Finally, what about a situation where it's the buyer at fault for the non-performance? We've spoken a lot about the seller, but what if it's the buyer? Well, again, for distributors, it comes back to what are the terms upon which the distributor is selling to the purchaser. In this instance, MP Distribution is the seller to Selfridges, who becomes the buyer. And we need to look firstly as to whether the parties are contracting on the distributor's own terms and conditions or on the purchaser's terms and conditions, and what each of these say about the remedies available to the parties. Depending on which terms and conditions apply, the courts will determine damages accordingly. For an agent, however, if the buyer is not performing, they will have no case. That's because there's no direct contractual relationship between the agent and the buyer. The agent is merely acting on the authority of their principal, the seller, who has the right of claim, and not the agent. Thank you very much.
Thank you very much. I'm not going very far away from my glass of water in case I have another coughing fit. That was wonderful. Thank you very much. We've all learnt a lot. I certainly learnt a lot that I didn't know already. I think we'll take lots of questions in a moment, but I did want to ask very briefly, from my own selfish point of view, on some of the things that you may have been seeing and you talked briefly about Brexit frustrating contracts, but some of the things that you were seeing at Fox Williams around the relationship between UK brands and perhaps their EU agencies. We've heard stories, for example, of German agents requesting that agencies become subject to German law, and just how worried should UK suppliers be, for example, if they're entering into new contracts with EU agencies? I know it wasn't quite the topic, but I've been really interested to know, and I'm guessing that a few other people might be as well.
Okay, I'll respond. Let me start by relaying two real examples. There is a client that we act for. It's in the north of England. It had pre-Brexit a large market in the Republic of Ireland, the European Union. To the extent that the Republic of Ireland business accounted for somewhere in excess of a third of its turnover and about half of its profit. In other words, it was a very valuable business that it had. But it decided that it wasn't worth the pain to be in a position where it was exporting and having to comply with the export restrictions, the export formalities, perhaps that's a better way of describing it, having enjoyed the best part of 40 years of free movement of goods, as far as the European was concerned, it just wasn't worth it. It abandoned its business in the Republic of Ireland, despite the importance of that business to the overall business. I was contacted last week by a company in the north of England. They act as an agent for a German women's wear brand. The German women's wear brand has terminated the agency, and it's terminated the agency for pretty much the same reason that our client decided to give up its Irish business. Pain was too much. The German company will, I suspect, go on to appoint a distributor, because the way in which it works, to express it very bluntly, is formalities are less painful for the supplier. I was talking before we went into the formal part of this evening and with someone in the room. They've appointed a business, or they've created a business on the continent in order to handle their EU business. And we've seen that repeatedly for a number of the clients that we act for. For those businesses that are using agents and distributors, or appointing agents and distributors in the European Union, and they still are, there is, in my mind, a fundamental issue to be addressed. And that is the basis, the contractual basis of the relationship between the UK business and the EU agent, the EU distributor. Why? Because of where we've ended up with the so-called trade and cooperation agreement. And we are now in a position where, certainly absent a formal contractual relationship which specifies the law that will govern the relationship, where that isn't the case, then the relationship, whether it's agency or distribution, will be governed almost certainly by the law of the member state and not English law. You can work on the basis that that is likely to be disadvantageous to you. And if you're not careful, you will find yourself in a situation when the relationship comes to an end, that you're in the EU member states courts rather than the English courts. In other words, you're playing away from home. In most cases, you'll be playing away from home with a language that you're not familiar with a legal system that you're not familiar with, and having the pleasure, I use that word loosely, of two sets of lawyers, your English lawyers and your EU member state lawyers appointed by your English lawyers to deal with. And the whole thing could have been avoided so easily, so very easily indeed. But that's right.
That's great. Thank you.
Does that answer the question?
That does answer my question. Thank you. Do we have some questions? Yes, at the back.
Say quite strong terms and conditions, but with people like us to order or a Liberty or a Delphi, they will sign conditions, but we will sign theirs. In that case, whose contract takes precedent? I think, like, especially with something like a retention title, how would it be executed?
It is possible, and the situation you described is quite common when you're dealing with a powerful purchaser, with a purchaser who says, thank you very much for your terms and conditions of sale, but we're not going to sign them, we're not going to accept them. In that situation, you may find yourself in a position where, as a result of the battle of the forms, you nevertheless win if you engage in that battle. You may find yourself in the battle of the forms where you lose. And in that situation, the likes of Selfridges, Limited, etc., their terms and conditions of purchase will kick in. Or you may find yourself in a situation where neither party's terms and conditions apply, and you fall back onto the Sale of Goods Act, which both Millie and I referenced. Sale of Goods Act will not provide for you to retain title to the, well, it will not provide for you to retain title. That's the short point. And therefore, if Liberty, if Selfridges fall over, you won't be in a good position. Hopefully that won't ever happen, although it is the case that it was February, March this year. The Times, I think, carried something of a story about Liberty going through hard times. There's no one here from no good. So going through some hard time and having to lay off staff. But hopefully it will never happen. Or if it does, I think we switch off the lights and put cat out.
I think the timing for your question is very important, because one of the things that we saw through COVID again, and I talked about things not changing, but everything has changed. And one of the things that we certainly saw at UKFT was a lot of companies going back into supplying goods to companies without having any exports cover or insurance, for example, because they know that insurers never actually pay out unless they absolutely have to. But what we have certainly seen, and you've certainly given one case, there have been a number of cases over the last 6 months of pretty blue chip businesses that before the pandemic were very solid, all of a sudden changing their business model to sale or return, for example, or indeed actually defaulting on payments or being very slow. So I think it is very important to look back at secure terms of payment, shoring up your business, even for retailers, for example, that were stable before the pandemic, because I think for a lot of them, business has changed. And some of the big ones, we haven't seen a big Japanese department store go down for quite some time, but when they do, they go very, very catastrophically.
And if I can just add to that, Paul, a few months ago, last autumn, we were advising one of our clients, this is a supplier to ASOS. ASOS asked it to, during the course of 2022, ASOS asked it repeatedly to delay supply, to delay the time when ASOS took the goods in. Ultimately, our client came to us, and we were fortunate, or our client was fortunate, that somehow had managed to establish that its terms and conditions of sale applied. And it forced the issue with ASOS, and the goods went in. I fear that that is probably the exception that proves the rule. The other situation that I anticipate some of you may be familiar with is where you are invited to accept a retrospective discount in respect of goods that you have supplied. There isn't an easy answer in that situation. All I can tell you is that there is a particular well-known retailer based in the north of England, I'm having to choose my words very carefully here, that was supplied by a sportswear company that we act for, and the sportswear company was invited to accept a retrospective discount, and the managing director of the sportswear company took exception to this invitation and instructed us to issue a statutory demand against the retailer in the north of England. And hey presto, a payment was made. And we said to our client, they will never order from you again. And the client said, we know, and we're fine with that. But unless you are prepared to do that, then it's a very hard position in which to find yourself in.
So
Sure.
a lot of it, I think, depends on the relation between the buyer and the seller and that the kind of power dynamics.
Yes.
And it's quite interesting that you gave the example of Brantano, because I did some business with Brantano 8 or 9 years ago when it was controlled by the Macintosh group with a large, I was working with a large brand, and actually they accept in the Dutch company, they accepted the terms and conditions of the seller because we were a very strong brand. In the UK, where we weren't a strong brand, they refused terms. So the seller, of course, then had that conflict as well. One company's accepted, the other one hasn't. And that was purely about the power of the, shall we say, the brand and how important.
Correct.
And I suspect that could be the case. And I'm sure, retrospective discounts. I think some of the big brands, of course, some of the luxury brands are able to say, take it or leave it. That's our terms. And I suspect the check's in the post the next day. Whereas a lot of the time, smaller suppliers are left to price counts on.
I think that's very much the case. You had a follow-up question, I think, to yours, didn't you?
Just going back to that, because I think would you say that in a case like that where there's not necessarily certainty that the credit insurance would say this protection, if there's nothing signed, but either party have credit insurance on an invoice without the retention of title, that necessarily?
I think you can. I'd need to check that. I think you can. I think the challenge that most businesses find is that the cost of the insurance is very high in the first place. I mean, we've certainly started at UKFT to work with a company, and I don't remember the name. We don't use them very often, but that will offer companies insurance. I know that government through UK Export Finance claims to be able to do the same thing, although I have to put my hand on my heart and say that I've not seen or heard of one case where a fashion business or a textile business has been able to use that. So that might be worth looking into, but I'll happily talk to you about that one separately. But it is a real issue, and secure terms of payment are very difficult to come by now because so many retailers are changing the way that they operate. So
if you're working with overseas distributors or suppliers, how does it work? Because a lot of contracts that are drawn up here only, as you say, is only abided under English law. How does that work? For example, say if you were wholesaling to boutiques in, I don't know, India, for example, they don't have to necessarily abide by those terms and conditions because the laws are totally different in different countries. I just wondered if you guys have that.
A large proportion of our work is international. So the starting point would be what is the governing law contract. You're right. Can be in a situation where the purchaser is located in the country and they take a view that they're not going to pay. You have to factor that into the contract you're entering into. And whether that means you get export insurance, you get credit insurance. One thing I would say is that where you're using insurance, and apologies if it seems I'm not flogging a dead horse, if I'm a dog with a bone, that's a better expression, is that you need to check the terms of the insurance. Would I expect the insurance to require that there is a retention of title clause in place? Yes, I would expect that to be the case. Otherwise, effectively, you're passing risk, you're passing a much greater risk to the insurer, and the insurer will price accordingly.
question at the back, Thierry, I can see.
Yeah. No, I really appreciated the fact that you said we have to choose our words wisely, whether it's loss majeure or others, because on occasion, unless mistaken, if you don't word it right for the retention of title, you could actually could potentially get the liquidator to keep the goods about the packages. But in relation to that, I've seen so many cases where some brands, retailers are not the best admin people on planet Earth. And could we play the game of sending them an email in the shape of, unless you respond to us within 3 days, I consider my terms and conditions basically valid. If they answer after that, or they fail to answer it, is that sufficient to win in court? Like you smile?
She likes a question.
Is that sufficient? It depends what has gone beforehand. Does that smack of almost certainly strikes me as varying the terms and conditions that have been presented to the counterparty in the first place. And I think you may well find yourself with difficulty in trying to rely on passivity on the part of the recipient.
Okay, I play smarter, I send a registered letter.
As what you're the form of the communication doesn't matter. It is what the communication says. And I think in that situation, what you're seeking to do is to vary your own terms and conditions. And then, because that's what lawyers are taught when we go to law school, when we're at university, is you then get into a situation of, well, did the other party accept the original terms before the terms were attempted to be varied by you? Did they accept the varied terms? How do we prove acceptance, particularly when pretty much everything these days is done by email? At what point did acceptance take place? And lawyers can have a whole lot of fun, usually at their client's expense, the other side's expense.
Just to add to that quick as well quickly, that acceptance by silence is not generally accepted as a as a way of
Which goes to my point about passivity.
exactly. And in that case, there's a lot of case law, very old case law about someone selling a cow or a horse. They were selling. I can't remember.
Four legs, mouth at one end, tail at the other end.
Yeah, you may have instances where acceptance is deemed by conduct, but again, it's a lot rarer and it's very difficult to prove.
And another case, thank you very much, Anne. Another case, what about I use their terms and conditions and I scrap number 7, I scrap number 8, I put see my terms and conditions apply. Suppose they don't respond, because I've seen that happen.
So you strike out 7 and 8 of theirs.
Yeah.
And you say, see my terms and conditions.
In
Right, so you're not accepting their offer.
I signed their offer, but I
No,
think
you haven't. No, you haven't accepted their offer. What you have done is put to them effectively a counter offer.
okay,
Now, do they accept your counter offer?
they don't read, that's why they accepted the file.
You hope. And
No, I said
then you end up in a dispute.
Yeah.
And then the lawyers come along and they've got 2 sets of terms and conditions, one of which has been partially amended by one party, and then they start to argue. Okay, that's the position we end up in. It is far better that there is, as clear as possible, a contract between the parties as to what that contract is.
Just trying to find it.
I know.
Yes.
From the perspective of an emerging brand, just attempting to sell to buyers for the first time. That. So you gave back the Selfridges example, for example. If Selfridges came to a small brand like myself and they wanted to buy a certain amount of units that was exciting to us, but they presented a contract, like you were saying, that favours them, and we presented a contract that favours us, I'd imagine they'd say no, they're not particularly interested in ours. And then because we're small and sort of unimportant in the vast scope of everything, they move on and we don't get Selfridges. And I'd imagine that would happen with other big brands and other big buyers. So can you speak a bit to the relationship between powerful buyers and emerging brands as they?
It's a difficult situation. At what point do you become a brand that Selfridges want to stock? They want to stock and quite possibly require exclusivity from you because they don't want you to be stocked in Harrods or Harvey Nicks or Liberty or online with Net-a-Porter or Matches Fashion. And you may well be in a position where you can say to them, look, You want me to accept your terms and conditions, but I'd like to know that I'm in a good position. So this is what we're going to do. And then you're looking at what they're going to order. You're looking at whether it's going to be an issue of exclusivity or not. You're trying to get the best deal that you possibly can, as I'm sure you would. But sometimes you may be in a situation where you have to accept their terms and conditions and take a chance that you're not going to be faced with an invitation to accept a retrospective discount in order to get the foot in the door with the likes of Selfridges.
Risk game.
Yeah, well, if it was without risk, we wouldn't be in business.
There's obviously also not as black and white as, either our terms apply or your terms apply. So there can be a situation where you get together and you try and vary the terms in a way that, suits both parties. So you might be prepared to give a few points in order to get some really important, big wins done, and prepared to give up some other terms that might be important to the big retailer, but not necessarily a game changer for you. So there's definitely ways of doing it.
No, there are ways, and bear in mind that the brands that we all think of as the big brands of today, they had to start somewhere. They didn't automatically become big brands. They were prepared to take the chances, the risks, to get there.
You got some more questions?
I would totally agree with what you both said, because it's about negotiation. If you manage to get in, the reasons why they're trying to buy from you, potentially you can still tweak the contract, but you know, and reduce the risk. Want to get in business or but yeah, negotiation skills are really important.
Any other questions? No? Well then, thank you. You've been an amazing audience. You've been amazing presenters, and I've just had a coughing fit. So thank you very much for coming.